So let me just introduce Robert Garson, our first presenter. He's the managing partner of Garson, Siegel, Steinmetz, and Fladgate. He was trained in the UK and at Cardozo Law School, from which he holds the LLM. He deals in complex business litigation, commercial arbitration, obviously the reason he's with us today, intellectual property, international law, and entertainment law. And he gave up a lot to be with us today because his daughter's 6th birthday is today. Or tomorrow, sorry. All right. Thank you. So, and I'll also introduce our second presenter, Chris Fladgate. Chris is an Australian-trained lawyer who's developed a practice over more than 15 years in construction, commercial, and intellectual property law, working in Australia, Hong Kong, and New York. And he's currently a partner at the firm of GS2 Law and a member of the New York State Bar. Gentlemen.
Well, welcome to this morning's session. Thank you very much to everybody here for flipping around the session so I can. It's my daughter's birthday tomorrow, and so when the schedule got shifted, she was really worried that I wouldn't make it. So everybody shifted everything around and moved heaven and earth so I can get back for a 6-year-old and present her with a bike, which she doesn't know she's getting as of yet. As you can hear, I'm not from Colorado originally. I'm not from New York originally, I'm from Britain. And our firm is GS2 Law. We call it that just because it's shorter than saying Garson, Siegel, Steinmetz, Fladgate, LLP all the time. And our firm was set up 4 years ago by a mixture of people who have dual disciplines. I'm qualified in Britain, I'm qualified also in New York, being a litigator back in Britain for 12 years defending people in serious organised crime, then coming over having done an LLM in intellectual property at Cardozo. And GS2 Law is what we like to call a boutique. That's another word for small, just so you know. A boutique litigation and arbitration house that specialises in complex disputes, especially within the business, international, intellectual property, construction arenas. I personally, what I do for the majority of my days is I litigate, I arbitrate, I advise people in relation to the construction of their contracts so as to avoid litigation and arbitration. Though it's my love, it's also one of my banes. It's one of those deep vices that one has. One loves going to court to speak on people's behalf, but on the other hand, it's something you don't really want to be doing at the end of the day. And this is one of the reasons why we're here today. I'll just pass over to Chris to introduce himself.
And good morning, everyone. My name's Chris Fladgate. Thank you for the lovely introduction, Phil. It's good to see everybody here. As Rob said, I do a lot of dispute resolution, meaning both litigation in court, whether that's state or federal court, as well as arbitration, which we're going to talk a lot about today. But for the meantime, I've done a lot of institutional arbitrations from the AAA, the ICC, which we'll talk about later, as well as FINRA, which has to do with financial bodies, as well as stuff known as ad hoc arbitration, which is where two parties don't submit to one of the institutions, but just say, let's just pick a third party to arbitrate. I've done a lot of that, and a lot of construction law, both from a contract side of things, representing the owner, negotiating contracts with developers and architects and the like, as well as litigation that comes out of construction disputes, which can involve arbitrations as well. So the purpose of our presentation here today is we're going to be sort of addressing a problem that we see in the world of dispute resolution with relation to arbitration. And we're going to pose a question or maybe a thesis that the Bataille Din can actually offer a solution or a way forward on this problem. So what we're going to do is we're going to set up, first of all, what arbitration is. So if I lost any of you just before, don't worry, we'll come back and I'll try to go slowly. I apologise for my accent. My interpreter didn't turn up here today, so I'll try to keep it as Americanised as I can. I'll talk about what arbitration is intended to achieve, as well as comparing arbitration to court-based litigation, why one party might choose arbitration over court-based litigation. And at that point, we'll start looking at the role that the Bataille Din may play in all of this. Rob, if you want to talk about what we're talking in the second half of the presentation about.
Yeah, what we're going to set up is a very specific form of question. As you can see by my law-branded kippah, that is one of the best advertisements one can ever have in synagogue, that Jews like arguing.
Really?
Right, it's true. Right from the beginning, when we see in the Torah, when God wants to wipe out Sodom and Gomorrah, one of the first things Abraham does is says, God, don't you think you're being a bit too hasty? Let me give our plea in mitigation on behalf of the people here. Let me find some people en route. Now, we have a very rich tapestry and a real history of having arbitration, institutional arbitration, and one of the issues that we're going to be bringing up is, can that be brought to bear within the commercial sphere, but also for non-Jewish people? Is it possible for two non-Jewish litigants to choose Jewish law to go before what ostensibly is an institutional Jewish law court? Should they choose it? Why should they choose it? And why should it be there in that first place? Because one of the issues that we see as litigators and arbitrators on the front line, we see this on a day-by-day basis, is that both litigation and arbitration has become unwieldy. It's become cumbersome. It's become remarkably expensive. And the funny thing is that the wealthier you are, or a person is, or the more that the dispute, or the more the amount of dispute there is, the better the form of arbitration or litigation that one can get. So, for example, federal court, where a judge is appointed by the executive or the president, as it will be, you need to have a dispute on the whole, which is either a constitutional question, a federal question. It needs to be $75,000 at its very core, and there needs to be people from different states. If you meet all of those, or some of those criteria en route, you can get a judge who's been appointed by the president, on the whole, a relatively intelligent person, as intelligent as judges can be, and they will look at your dispute. However, on the state court level, within New York especially, if one wants to have the commercial judges, those who on the whole are better, your amount in dispute needs to be $500,000. Otherwise, you don't get a commercial court judge. So if it doesn't meet the $500,000 threshold, you're then thrown into the pool of usual New York Supreme judges. Not saying they're terrible en route, but they're not the commercial court judges, they're not federal court judges. So what happens to the people who have genuine business disputes that are of real value to them that don't meet the $500,000 threshold? Should they have to be thrown into New York litigation, which can be remarkably costly, thankfully for us sometimes, or New York arbitration, which, as Chris will show, has also become remarkably costly? What is their other alternative? And what we are going to propose is that can be found within the Bet Din. Let me over to Chris.
So first, let's take a step back and go through what arbitration is. You might have heard of it in the news, you may have read of it in the newspaper, not quite understood what it really is. So let's just going to keep it simple. First of all, it's a private agreement to resolve disputes before an agreed third party. So Rob and I may agree, we've got a contract to sell widgets, and if there's a problem under the contract, we'll get IRA to resolve our disputes. Okay, that would be an example of arbitration. It basically takes you out of the court system and places you your dispute before somebody else. Now, in terms of making that enforceable, there's a strong the courts have adopted a strong public policy in favour of supporting arbitration agreements and also the outcomes from any arbitrations that occur. So, without going into the details, is effectively an arbitration agreement. Once you go to arbitration, it's resolved, it has the same effect as a judgment. Okay, so it works the same as a judgment. So in some ways, before you get into a dispute, you can view it as two different routes to resolving your dispute. Do we go through the courts, or do we go through a private process, and both lead you to the same end, where you've got a judgment in your hand that you can enforce against the other party if you're the winner. Historically, the way arbitration arose, look, we could go back to 1000 BC, we could go back to 1500 years ago. I'll take you sort of from a leaping point yesterday where Tyler finished, which was at the end of medieval times and the dawn of the Renaissance through Europe, where what you had was a merchant class rising up in Europe, and merchants by their nature had to deal with people from different states or different countries, different jurisdictions, neither of whom wanted to submit themselves to the other person's jurisdiction. Someone from Florence probably didn't want to be subject to the courts of England, and vice versa. So what they often agreed to in their contracts was, well, if we have a dispute, we'll let this other person who knows our business very well rule on the dispute. And the simplest version of that I remember hearing was on the docks in London, when the grain came in and there'd be an issue over the quality of the grain. Two people would go to another grain merchant and have the grain merchant pick up a handful of grain, let it run through his fingers, and he would then decide the quality of the grain. And that would work out the contract price, and the dispute was done. It was simple, it was clean, and everybody got to keep on doing their business. And so what we've seen over time, if we want to move it sort of forward now more into the 20th and 21st centuries, is that what courts look at when you say, we agreed to arbitrate, Your Honour, is where is that agreement? And often there'll be a one clause in a contract that says, if any dispute arises under this agreement, the parties hereby agree to submit their dispute to arbitration pursuant to the American Association of Arbitration, American Arbitration Association, the AAA, which I mentioned earlier. And that is all a court will look for, is something like that. Did the parties agree? Now, it's interesting at a legal level is once the parties have agreed to arbitrate, that agreement acts like a mini agreement within the broader agreement, such that if one party then argues, well, look, I only signed this contract under fraudulent pretenses, or parts of this contract are unenforceable or void, a court might say, well, you know what, the arbitration clause is still good, you've got to make those arguments about fraud and invalidity before the arbitrator, unless you can show me that you didn't mean to agree to arbitration. So courts, as much as they can, will try to push things out to arbitration if they can.
Just pausing on there. One thing, just so you know, within the institutional arbitration environment, we as lawyers are husted, we are approached very often by the different institutional arbitration bodies, such as the AAA and JAMS and other arbitration bodies that there might be, to ensure that their clause is placed within the contracts that we negotiate for our clients, because that's where their hook comes from right from the beginning. So dinners, parties, etc. Please make sure that our clause, because we're competing against them, and them, because after that happens, and that contract can last for 20, 30, 40 years, hypothetically, they are the exclusive institutional body for any dispute. So many of the clauses say any dispute that arises out of this contract must go to that institutional body. And we are, as I call it, husted, approached, and lobbied very hard in relation to that.
That's right. And you see some form contracts try to press arbitration on the parties, where the first option for dispute resolution is arbitration pursuant to the AAA or something like that. So why do people choose to arbitrate? There's a number of reasons, and I'm going to go through them quickly because a lot of these reasons more recently have come under attack or aren't so valid anymore as reasons. So the first one off the bat is there's a perceived cost benefit. Typically, we'll go back one step. They can be resolved. Arbitrations typically resolve themselves more quickly. There's a speed element, and people like the idea of basically being able to say, "Look, I don't want to get mired down in court litigation where there's a motion every month and an attorney doesn't turn up to a conference, so the case gets held over, and we never move towards trial. What I want to do is get the dispute before somebody or an institution we trust and get it resolved. And if I lose, I lose, and if I win, I win. And we'll get to justice more quickly. And flowing from that is the cost implication. Is typically, if something happens in less time, it will cost less money than something that takes a greater amount of time. Now, as we're going to see later, that's not always the case, but in a lot of instances, the cost implications of arbitration, you get to conduct your arbitration for much lower cost than a full-fledged litigation before the court. Then you start getting to some of the more particular reasons people prefer arbitration. And the one that sticks the most to me is that you actually get to choose your decision maker. And this can be very important to people who are in specialized industries or something that you might feel this could be difficult for a judge or a jury to understand. And what you can do is when you pick your decision maker, they don't need to have a law degree, they don't need to be a judge, they can be anyone who you trust to render a valid decision. And that can be very important to some people to be able to say, let's put, if we have a dispute, everything's good now, but if we have a dispute and things aren't good, we're going to trust, IRA to make a wise decision and solve our dispute. Following on from that, as I alluded to before in relation to an arbitration giving you the equivalent of a judgment, is you get finality with arbitration. I can't speak for all 50 states, but as a general rule, it is very hard to appeal an arbitration award. In New York, for example, the two bases you can appeal are bias by the arbitrator, and bias is extremely hard to prove, by the way, and fraud in the arbitration, which is essentially that the arbitrator took a bribe. And again, fraud, as any attorney should know, is actually quite hard to prove because you have to show, and not just that something bad happened, but there was an intent behind all of that. So they're very hard to prove. So you know that once you've gone off and got your arbitration, got your decision, that's sort of the end of the story. You can't be locked into interminable appeals through the court process. That's it, it's done. And so following on from that, another reason parties like arbitration is the simplicity. Arbitrators are not bound, believe it or not, to follow the rule of law or the rules of evidence in the arbitration. They can choose to do so if they wish, but they're not mandated by law to do so. And what this means is you can throw out all the civil practice codes in New York and Colorado and California. You can't cite any of those provisions to an arbitrator and say, I demand the right to take 12 depositions. I demand the right to have the other side produce 500,000 documents and have me have 3 months to review them. An arbitrator will say, no, that's just, to me, that's irrelevant. Look, you can take one deposition for 3 hours, you can make document requests into this field, you'll turn them over, you'll get 3 weeks to look at them, and then we'll have a hearing in 6 weeks. So you can get arbitrators cut through all of that because they're not bound by the rules of civil procedure. And look, those rules are important when you're in a court context. But if the parties have decided to take themselves out of that context, then an arbitrator should be free to basically say, look, this is a dispute, this is what I want to focus on, let's just focus on that. And then the final sort of reason a party might decide to do this, before we get to one interesting benefit Rob will talk about, is privacy and confidentiality. Obviously in the court system, everything is on the not everything, but most things are on the public record, certainly in terms of when it comes to judgments. They're all on the public record, and some parties are averse to having that sort of publicity, or averse to being able to be found on a Google search or a LexisNexis search or something like that. They want to keep their business disputes tucked away out of the public's eye. And just on that, I just pause briefly. There is a slight distinction between privacy and confidentiality. Arbitrations, unless there's an express agreement for them to be kept confidential, are typically seen as being private. And all that means is it can occur without sort of the public knowing, the public being able to walk into the room or anything like that. If one side decides to disclose what happens in an arbitration, unless there's a confidentiality provision barring them from doing so, you don't have much remedy to that. But certainly compared to courts being on the public record, you get a greater degree of privacy when it comes to arbitration. And then we have the idea of interim remedies in New York.
One area which I love for when it comes to arbitrations is the concept of interim remedies. So let's set up the problem. Somebody has stolen, let's use IRA. Because everybody seems to like him.
I was the judge.
Right? Somebody's stolen from Judge Ira, and he wants to arbitrate against that person. Within the context of arbitration, especially within New York, one can freeze that person's assets in aid of arbitration. We call that attachment in aid of arbitration. No judgment has been rendered as of yet holding that person liable, but you can go and freeze that person's assets. Now, one could hypothetically do it in the field of attachment in aid of litigation. We call that interim attachment. But when it comes, especially within the New York field, It's very difficult to do so in the context of litigation. One would have to show success on the merits. One might have to show the person is not resident in the jurisdiction. Somebody's about to leave the jurisdiction. Somebody is secreting their assets so as to frustrate collection at the end of the day. Quite difficult. It's a harsh remedy. Judges don't like it, especially on a pre-judgment basis.
Very high standard.
Very high standard. However, when it comes to attachment in aid of arbitration, there's a little known area of the CPLR, that's the Civil Procedure Rules in New York, known as 7502C, which allows for attachment in aid of arbitration up to, you can start it 30 days prior to even serving the demand for arbitration. So 30 days, the other person doesn't know that arbitration is going to happen. You can bring them into court, go to a court and say, I want that person's assets frozen on a very low standard, which is that the arbitrator's award might be rendered ineffectual. Very broad, very easy, and because judges like arbitration, there's a positive mandate towards it. They say, yes, thank you very much, get out of my court, come back when the award has been rendered. And that attachment and aid of arbitration, as long as the arbitration starts within 30 days, can be served on banks, can be served on the other side, a person's assets can be frozen here, there, and everywhere. So it's one, and not just in terms of domestic arbitration, but also in terms of foreign arbitration. So if you're arbitrating against somebody in Singapore, and we know that a person has a bank account in New York, one can go to the court in New York and say, we have an arbitration agreement. There's going to be an arbitration in Singapore. This person has a bank account here we can identify. Freeze it. And it will be frozen, and it can be frozen. It's very easy to obtain, especially within the state of New York. And there are other states that have similar provisions that are there. Yes?
Sorry, I have to ask. Is it subject to tremendous abuse that you could do it because it's such a low standard and creates an advantage in relation to negotiation and all of that?
Very hard to fight against.
Yeah.
Yep.
Yeah, if people knew about it, and many people don't know about it, then I presume it would be subject to a great deal of abuse. It's very difficult to fight against, and one of the main benefits especially is that it causes strong provisional remedies, cause people to come together very quickly, not to take adverse reactions. If you've managed to stranglehold somebody's ability to spend on themselves, then yes, and that's why the worldwide freezing order is very powerful in Britain, for example, but that's more on a litigation basis. Yes, sir?
It can't apply in a criminal situation, can it? And you said the example you gave suggested a crime.
Oh, I was talking about civil fraud, but hypothetically that could work, that there are different criminal mechanisms whereby, for example, the DOJ, the SEC, the CFTC, they've got their own mechanisms to go and freeze somebody's assets.
So let's start getting to the good stuff, the bet din and all of that. As I alluded to before, we're seeing increasing problems, particularly with institutional arbitration, both in America and internationally, to do predominantly with the top two reasons people would choose to arbitrate in the first place, relating to cost and to time. In relation to cost, costs are going through the roof in relation to institutional arbitrations, and it doesn't take too long to work out why. Number one is a lot of the institutions, and this is just the institutional fee, will base their fee on the value in dispute. The AAA does that, and the International Chamber of Commerce, the ICC, does that as well. So they have a scale, and they say, if your dispute is up to $100,000, you will pay 2% of your dispute value. If your dispute is between, $100,000 and $1 million, you'll pay, 1.5%, and it keeps going up like that. That fee is typically due at the start of the arbitration. It's to accompany your demand. So when you're faced with the option of, well, do I go to court where it doesn't cost me anything just to get in the door versus arbitration, you've got those costs. The follow-up cost, and sometimes this is more the killer, is the arbitrators now are typically experienced lawyers and retired judges, all who, we had an arbitration recently, and you get the resumes in and you get to try to pick your arbitrators. The starting point was $700 or $800 an hour. Now, if you're in an arbitration where you've agreed to be in front of 3 arbitrators, you're looking at paying these people, north of $2,000 an hour. And that's not just to sit and hear the arbitration. That's all of the preliminary work in terms of reading the submissions, dealing with, say, disputes over production of documents, as well as, reading opening submissions, attending the hearing, reading closing submissions, and writing their award. The costs can go through the roof, in short. And that is, and we'd submit the reason for that is typically what's happening in institutional arbitration is it's becoming more lawyer driven. People who have civil procedures ingrained into them want to try to transplant those civil procedures into an arbitration context, and the arbitrators are happy to go along because, hey, they earn more money the more complex they make the dispute, and the lawyers earn more money because they're all charging by the hour. And similarly, the flow on from that is if the cost goes up, as we talked about before, the relation between cost and time, the time it takes to resolve these disputes is typically dragging out longer and longer, almost to the point where, if you can get into federal court, you can get, depending on the complexity of an issue, you should have your dispute done in federal court between 12 and 15 or 18 months. Arbitration's becoming closer to that time period as well for a similar dispute, and yet you've got a lot more fees attached to it. So, what's our solution, Rob?
Well, the solution for us was looking at what I've been calling the original Triumvirate.
Now I was raised a Catholic. That would be God, the Son, and the Holy Spirit, right?
No. I'm talking way before that. The original Triumvirate, which was, as we know culturally, we have right from the beginning of Judaic history the concept of being able to arbitrate our civil disputes on the whole before a neutral, 3 neutrals, and we have a remarkable history and wealth of scripture that shows documenting that case law, that goes even to the most minute level, that if a father dies and leaves his son in debt, and that debt was secured by X quality land, what land should his son have to pay back the debt for the father on? And it's remarkably complex in terms of civil litigation and what those rules can be. Now, my background in Britain, just so that you're aware, I sat on the Board of Deputies, which is like the Jewish Parliament. They're representing all the Sephardic communities in Britain on the Defence Division, and understand, and our firm works a great deal with the ultra-Orthodox communities and non-Jewish communities. We don't discriminate, as you can see.
Let me work with you.
Yeah, well, you let me work with you as well, but because of the beard, most of the people think... People are very confused by the whole Chris thing. But we are people that delight from the very basis in loopholes. Jews set up a law and then immediately have their loopholes.
This is news to me.
Right from the beginning, from the concept of Eruv, putting how one can carry on the Sabbath. We're people that delight in that right from the very beginning. Now, Batei Din, especially on an institutional level here within the United States, have become glorified divorce courts. They've only...
It's where you go to get a get.
It's where you go to get a get.
I've learned something.
Right? Well, where hopefully some ladies can go to get a get en route. But their province has been, on the whole, only within the area of divorce. There's been a very slow growth within the United States for people who are arbitrating their disputes to go to the Bet Din on a civil basis. And and on a personal level, I do not understand why. Because what one has here is a wealth of people, especially within the Bet Din. If one looks at the Bet Din of America, which is where one of their main hubs is in New York, they have remarkably qualified people. Many of the rabbis or dayanim, people who've taken the higher levels of exams within Jewish law, are also qualified lawyers. And when they have a specified area such as intellectual property, they like to bring in people who are specialized in that area. Whereas in court, when we go to court, I don't know if my judges ever practice intellectual property. I would have no idea what a patent is, would have no idea what a copyright is, and quite often will make mistakes between the two en route. So one finds oneself having to educate the person en route. Whereas within an institution like the Beth Din of America, they have the facility to bring in people who are specialists within this area. Now, as we spoke about earlier, one of the big conflicts that we have when constructing contracts between two adverse parties or two parties within a civil context is the nature of the arbitration. Now, sometimes it can get as complex as there's going to be arbitration held in London in the French language according to the law of Singapore. Because certain people don't want it. A person from Louisiana might not want the law of Texas, and a person from Texas might not want the law of Louisiana. One very interesting concept is that Jewish law on the whole applies right across the board. There is no jurisdictional divide. One may have a divide as between how different ad hoc tribunals, so a Satmar tribunal may interpret certain areas of law vis-a-vis a Chabad tribunal, if one's going to go within the ultra-Orthodox sphere, or as a Sephardic tribunal might be. But one is talking here not about those ad hocs, we're talking about the more institutional form of Judaic arbitration that there might be.
So could two non-Jews go there? That's my question.
Well, that is your question.
Can I go there?
Right, and this is, could you go there? Now, when we started this area of research of could two non-Jewish parties submit to Jewish law, the answer from a civil legal perspective, there is no reason why not. Any arbitration clause, as Chris has already stated, is a creature of contract. You and I, sir, could go to war, could go for arbitration according to the law of Papua New Guinea, if we wanted to be held before an imam. So there's no reason why, from a contractual position, that two non-Jewish people could not submit to Judaic law. The question is, would the Batei Din, would the institutional Bet Din accept it? And this is where, and I'm not just saying it because I'm Sephardi, because I fall within a very narrow form of Sephardism. I'm Spanish and Portuguese, so all of the Ashkenazi Jews think I'm white, and all of the Sephardi Jews think I'm Ashkenazi. So I fit there squarely within the middle. But when going and asking all the different rabbis, and we did quite a large survey, would you be able to arbitrate a dispute between two non-Jewish people, a very clear ethnic divide occurred. The Ashkenazi rabbis said, well, it's very difficult. Oh, it's very difficult. And they looked weighed down by the burden of just a simple question of could you solomonically arbitrate a dispute between two non-Jewish people? The Sephardim, on the other hand, and it was unanimous across the board, said, of course, why not? Where do you think when we were in Sudan, Libya, Algeria, Tunisia, Syria, Lebanon, Morocco, where do you think the locals came for their justice? They didn't go to the local courts because they would never get any form of justice there. Everybody used to come to the Bet Din, and especially when one looks at, they've got a very well documented case law and history within before the Batei Din of Aram Sova of Aleppo, of non-Jewish people coming before the Batei Din and having their disputes arbitrated according to Judaic law, because that was the only body and corpus of case law whereby people can understand what they were getting. They had respected arbitrators, they had unanimity in how there was, or not unanimity, they had an understanding of how their cases were going to be decided, and therefore on a non-Jewish basis were very happy to submit themselves to Jewish law. So the question is, why would the Batei Din, the institutional Bet Din, not accept non-Jewish parties? Because they do accept corporations. If one looks, we'll speak about this very briefly in due course, if one looks at the publications of the Bet Din of America, they do arbitrate between two corporations. Sometimes corporations who don't have Jewish shareholders. We know a corporation is a legal person. A corporation cannot be Jewish. So whether or not certain corporations are partnerships, etc., if they've got two Jewish partners, not a corporation isn't Jewish. So if they can arbitrate between two corporations, why not between two non-Jewish people? So we say that there's history that would show within the Sephardic institutional arbitration that can be done. The question is, are they marketable? Why would somebody want to go before the Bet Din? Well, we've already spoken about the talent pool that is there. And we say there is a great talent pool of people who've been sometimes in yeshiva for up to, so Jewish learning seminaries for up to 5, 10 years, then taken their law degrees. Some of them are practicing lawyers, some of them are judges, whereas many of my judges that I might come before in New York Supreme, their qualifications are, they had a law degree and they're in practice. And that's it. And they got elected. Well, of course, we know that elected officials are remarkably competent at all points.
So would they keep it simple, or are they going to weigh us down with law then?
No, well, you see, there is Judaic law, but there's one wonderful mechanism that is there, that sits right in the middle, which not many people from the non-Jewish world know about. And when people are talking about arbitration, as Chris spoke about, you're looking for swift, common sense decisions where somebody isn't tied to the law and says, well, because you haven't abided by the statute of frauds, I'm not going to uphold the contract, which I know in my heart of heart is right and correct. And that's where Jewish procedure has a concept known as peshara, whereby a Jewish law court can say, all right, you've not abided by the strictures of Judaic law, but we are allowed to, and we are permitted to, come to a decision despite the law. A decision on a gut reaction, common sense basis, and we can render an award on that level if you agree to allow us to do so. And on the whole, they do allow them to do so, and the awards, so one could have, let's say, on a breach of contract case, I was going to be awarded $1 million, but because the arbitral body said, well, we agree that you should have something, but you don't abide by the strictures of the law, we're going to give a peshara decision here, we're going to cut your award by 1/3, because it's not in accordance with the law, and the award is going to be reduced accordingly. And one of the main objects is myself, as somebody who's taken their mediation training, who has looked towards arbitration, people look to have a win-win situation. They look to be vindicated legally, but on the other side, people also, if they do lose, want to know that they haven't been really taken to the cleaners. And the concept of peshara, which is there, which is available, a common sense, natural justice, basic equities decision, not only is there, in fact the Bet Din prefer to give judgment on that basis, and when one looks at the annals of the Bet Din of America, they more often do than sticking to the strictures of the law, which is actually what the arbitration was originally set up to do.
So, is the Bet Din missing a huge opportunity here?
No, well, that's one of the things that we've been looking at, that from a marketability perspective, we believe that they are missing a large opportunity. Their process, rather than being adversarial between lawyers, is very inquisitorial, it's very judge-driven, it leads to much more increased savings for the parties that go before there. They are very targeted in form of their in terms of their disclosures. The hearings are much shorter, and we believe that there is something there that can be marketable. And they also have entrenched within them the possibilities from the Civil Court of Interim Remedies, which is entrenched into their own rules and their Bet Din procedures, where they also allow themselves their own interim remedies. So if we're looking to round up what we're saying, can non-Jewish people go before Bet Din? Well, contractually they can. Is there a history and track record of Bet Din arbitrating disputes for non-Jewish people? Yes. Should it be preferable for non-Jewish people to come before Jewish law court? Well, that's for them as to whether or not it should be, but there are certainly the cost savings that will give them the access to justice and the talent pool that we believe on a commercial level is being wasted by the Bet Din at the moment.
Thank you.
Thank you very much.